Okay. So, ladies and gentlemen, all those of you who are present here in Olomouc at the Law Faculty of the Palacký University, and all those of you who are watching online, welcome. I'm very pleased to welcome you to this first lecture within the Olomouc International Law Lecture Series, which is organized by the Faculty of Law and its Center for International Humanitarian and Operational Law here at the Law Faculty of the Palacký University. My name is Martin Feins. I'm the head of the center. Together with me are not just my colleagues from the Law Faculty, but especially our distinguished guest, Professor Erika de Wet. Professor, I would like to introduce our guest. Professor Erika de Wet is a professor of international law at the University of Graz and an honorary professor at the University of Bonn. She's also the co-editor-in-chief of the esteemed Max Planck Yearbook of the United Nations Law. Professor de Wet has lectured substantively at inter alia the University of the Free State in South Africa, the University of Pretoria, the University of Amsterdam, and University of Zurich. She has published in leading publishers and journals of international law and is globally recognized as a leading expert in issues of public international law and particularly on the use of force in international law. It's my great pleasure to have you with us, Erika. Welcome to Olomouc for the first time. I hope that you will come more often, and we are very thankful that you accepted our invitation and that you accepted also our request for having this lecture, which will concern the issue of aggression against Ukraine and the Austrian neutrality. So without further ado, I would like to hand over the floor to you.
Thank you very much for that very kind words of introduction by Professor Feins. And it is a real pleasure for me to be here in Olomouc for the first time, but hopefully not for the last time. It's a very beautiful city. The weather is very cold, but that has nothing to do with Olomouc. I think it's the whole region. It's no better in Graz at the moment, but it is still a great pleasure to be here. And I would also like to extend my thanks for everybody who has made the time to come this evening. I'm looking forward to a very interesting discussion. And also I'm delighted to see that several members from the military are here. And I'm sure that I can also learn more from you this evening than vice versa. With some of the issues which I will raise questions, but I don't have clear answers for, and perhaps you may have some interesting ideas on that. And also, I would like to thank Dr. Marko Savicevic for having organized this. And we know one another since many years. Marko still studied with me when we were both based in South Africa. So just that you know, I am not Austrian by birth. I am a proud Dutch national now, but I'm also, I was born and raised in South Africa. So my socialization, my upbringing is a bit varied, and my perspectives are also, of course, influenced by the fact that I lived 33 years in Africa, in Southern Africa, and that I was also educated in Western Europe, in the United States, and now live in Central Europe. And yes, so that is enough said about me. I will speak for 20 minutes on the topic so that we have sufficient time for discussion. And if people are interested, I have a short article of 12, 13 pages coming out on this topic in a Festschrift, which will be published very soon. And I already have the proofs available, but just I can forward that to people if there is interest afterwards. Can the people online hear us? Do I need to speak into a microphone? Or
there is a microphone, so everything should be fine.
This one.
Yes.
Good.
So everything should work, and we are online.
Good. Okay. So, as you are aware, since the aggression against the Ukraine since 24 February last year, the EU has adopted far-reaching economic sanctions that extended extensively also beyond the sanctions against Russia that it adopted after the annexation of the Crimea. And these also included lethal and non-lethal military assistance. there was economic sanctions on the one hand, but also assistance in terms of the financing of military equipment, for example, and through the member states' military equipment. Now, Austria, together with, I think, Ireland and Malta, are not neutral states. So this placed them in a tricky position. And when these measures were adopted, Austria engaged in what is known as constructive abstention, which the EU founding treaties explicitly provide for. And it allows the country to abstain, but without blocking the decision. And it also did not actively implement any of these decisions. And in exchange, then it makes additional humanitarian payments and so on. There's a way of facilitating this, but without directly participating. However, Austria is permitting the transfer of arms through its territory. And this is where one of the issues with neutrality comes in. The Swiss are not doing this, but they have a different geographic, well, they're not in the EU to begin with, but they also have a different geographic context. With Austria, due to where it is positioned geographically, it's tricky to get certain military equipment and things to the Ukraine without actually either passing through Austrian airspace or crossing Austrian territory. So you see that there is this tension between Austria's permanent neutrality and its EU membership. And since 1955, the federal constitution of Austria guarantees the country's neutrality. It entrenched the the international law notion, construct of neutrality in the constitution by means of a unilateral act. And this was a condition for Austria to get back its sovereignty, because until 1955, after the war, it was occupied. And in particularly Russia at the time insisted on Austria becoming a neutral state in order to remain neutral in order to regain its sovereignty. However, Austria has always insisted that this decision to be neutral was taken voluntarily, and there's no treaty guaranteeing it, but it's through a unilateral act, which is also recognized under international law as binding in its constitution. And in a sense, it means no military alliances, no foreign military bases on Austrian territory, and no participation in international armed conflicts. And these basic principles of neutrality were entrenched in the Hague Conventions of number 5 and 8 of 1907, but they also constitute elements of public international law. Now, you already see the problem here in the year 2022 and 2023. We are applying a construct which was designed in 1907, which, when I'm correct, there were no airplanes yet. In the First World War, there were some planes, but I mean, it was just the warfare have immensely evolved. Yet these treaties have never been updated, and state practice is few and far between. So on the one hand, that leaves big gray areas. It makes unclear what is permissible, but it's legally tricky. But according to the international law of neutrality, a neutral state, a permanent neutral state like Austria, is not allowed to have any troop movements over its territory or supply movements, no transfer of war materials. There is a debate currently to get around the fact that military equipment is being passed through territory. There is a debate amongst military lawyers whether this only concerns lethal weapons versus all materials. Now, I am not sure that it's always that easy to distinguish between what is lethal and what is non-lethal, but probably there are gray areas, but there are also clear differences. but in the older traditional literature, it was clear that actually no military materials can be transferred. And there may not be any military trade by the state. This concerns, we're talking about an international armed conflict, which we obviously have in the case of the Ukraine and Russia. And we talk, no military trade is allowed. You cannot say I trade with both sides, so they both treated equally. No, you're not allowed to trade militarily if you're neutral. And one of the principles of the ideas behind the neutrality, part of the philosophy, is to contain the expansion of the conflict. You want to keep countries out of the conflict because of the humanitarian goal of containing the conflict. And in exchange for keeping out of all these military activities, no military activity may take place on the neutral state's territory. Non-military trade is not affected. I'll get back to that point. So you can actually impose sanctions against Russia when it concerns purely civilian goods or some non-military things. But once again, you have huge categories of dual-use goods. And that's where I also think a lot of difficulty come in. But the idea is you're not politically neutral, and you can also decide we're not going to trade anymore in any kind of civilian stuff. That's fine. That you can do in a one-sided manner. This is about military support. In the old days, until I would say at the end of the Second World War, because this was like obligations on the state. Okay, so private companies could still trade in military companies. They could still sell their weapons to whomever. But of course, in modern democratic states, the export of any military material needs a license. The state needs to issue authorization. You can't just export lethal and other military things as a private company without being regulated. You need usually a license for that. And because the state is involved in the licensing issue, of course, they immediately have the state involvement. So these days, it actually covers the prohibition of trading in military goods applies also to private firms within a neutral state. Now, what is important is that non-neutral conduct. For example, if a neutral state violates an obligation under the law of neutrality, that doesn't in and of itself means it's now a party to the conflict, that it's become a co-belligerent. It's a violation of neutrality, which means it may be facing countermeasures, like some sort of restrictive economic measure, like a sanction, or for example, that Russia may decide to stop all gas flow to Austria. Something like that. You must be aware that you will face some kind of reaction, or you make, if you violate the law of neutrality, but it doesn't in and of itself mean that now your neutral status has now ended, and that doesn't have to mean that, and it neither means that you have now become a party to the conflict. The type of violation is decisive to determine co-belligerency. And this is a slippery slope, and it's also problematic for states that are not neutral in the sense that Austria is neutral, but simply who do not want to become a party to the conflict, a co-belligerent. Because at some point, if you say, look, we support the Ukraine, but we're not a party to the conflict. We're acting non-neutral in the sense that we're supporting the Ukraine, but we're not a party to the conflict. Also, in that context, at some point, the type of assistance that you provide may be of such a nature that, of course, third states, other states, and in this case, the aggressor, Russia, may decide, no, we don't regard this as you have crossed a certain line. And this is the problem with these, it's a decentralized decision. It's not only what Austria thinks or its EU partners think about the type of assistance that it's giving. It's of course also the other parties to the conflict and other states. And this is what makes it so unpredictable and of such a slippery slope. Now, it seems that if there's a very, very direct, clear nexus between the type of aid that you're giving to a country such as the Ukraine, if there's a direct nexus and the type of aid is somehow, without that aid, a certain kind of military action would not have been possible, then you can be regarded as a co-belligerent. That happened in the Iran-Iraq war, in the 1980s, where already at that time, Kuwait and Iraq were actually together against Iran. And for 3 years already, between 1946 and 1984, Kuwait supported Iraq with logistics, financial aid, military equipment. There was a lot of aid to Iraq. And Iran protested against this, but it did not regard Kuwait as a co-belligerent until 1987, 3 years afterwards, when actually Kuwait allowed its harbors and its airspace to be used as a launch pad, because attacks from there were then launched against Iran from Kuwaiti airspace, from its harbors. So you see, that's that very causal link. Without having a specific attack would not have been possible if they had not provided that type of facility. And so what is being debated is the extent of military intelligence being provided. If the intelligence says, okay, that ship is exactly there at that moment, so if you want to take it out, this is what you need to know. So if that type of specific information, it's risky, because you can argue that the causal link is extremely tight. Without that type of assistance, probably taking out a warship or a certain military target would not have been possible. And the other practice that we have in recent times is the Iraq War of 2003, where some countries also in Europe and like also Italy supported the United States in the illegal invasion of Iraq of 2003. But Italy, interestingly, supported, but it made a non-belligerency declaration. It actually said, look, we are supporting the United States, but we are non-belligerents. It actually made a very clear position, because it provided all sorts of other aid, but it wasn't participating militarily in the conflict. And of course, if you directly enforce a no-fly zone, that would definitely be a violation of neutrality, because how can you do that? And it would also mean you would be a co-belligerent then, and the neutral status would end, because you're actually shooting down the planes of the enemy. So this is what I mean with a direct causal link with the belligerent act, acting as a launch pad. And this is where I don't really know, and the military lawyers will be much better informed about this than me, and I'm very looking forward. Interesting, it's maybe a question from me to you. The issue of providing fighter jets, because it's not clear to me how you move a fighter jet from a neighboring state, supporting state, into the Ukraine, for example, without acting as a launch pad. Now you can argue, yes, but we're only flying the plane there to be used later. But of course, how should the enemy know that the moment that the plane actually enters the war zone, it's active? So to me, and perhaps that seems to me a very, very tricky issue to deal with. And I don't know enough about the logistics and the techniques around that, whether you can actually dismantle the plane and have it transported in another way. It's probably very, very cumbersome, but there is a real issue there about becoming a co-belligerent at some point with a certain type of aid. And this was debated also on all sorts of blogs and things. And the German Bundestag, the German Parliament's legal division, actually, they were asked questions in Parliament about this, and they also raised a concern about this. Now, when is neutrality not violated? If there is a Chapter 7 resolution of the United Nations, which we do not have in the Ukraine context, that authorizes the use of force, first of all, these authorizations, now there's a big debate in international law whether these authorizations under Chapter 7, because if you look at the Charter, both Article 42 can be used as a legal basis, it's as a basis for the authorization of the use of force, but also Article 51, some states claim. I personally do not agree with that, but Article 51 to me is the decentralized classic self-defense. But when the Council acts and authorizes the use of force, I would say you use Article 42. However, I have to emphasize that there are differences amongst the states about this. The United States and the UK, for example, in the United States and Israel in the first Gulf War, 1990, insisted that that Security Council authorization was based on Article 51. Okay, so that debate is going on. That being said, if the Council actually formally triggers Chapter 7 and authorizes the use of force, that is so-called police action on behalf of the international community. It's not regarded as co-belligerency in the sense of that we're talking about. It's collective action. So the Council then only authorizes states to use force against another state. It doesn't oblige any state. So any member of the UN can then still say, okay, thank you, but we'd rather not participate. But if they do, if like Swiss and Austrian troops are in Kosovo under Chapter 7 and have been there, there has been a Chapter 7 resolution of KFOR now since 1999. And that has been accepted. It's not regarded as a violation of neutrality. So, okay, if there's a Council authorization. That's the policing issue. Now, sanctions is a non-military. Now, sanctions can violate neutrality. If you, like I said, military sanctions, a neutral state cannot survive any military support to either of the warring parties. And one-sided sanctions that affect things like arms embargoes and so on, and oil embargoes, things that are very closely related to military capacity, that would violate neutrality. But if the Security Council has authorized such sanctions, like in the Iraq War, and has authorized the permission of troop movements and so on. Okay, well, I think I'm in the military sphere again, but it has authorized sanctions like was the case in the Iraq War. Then it is now accepted that there is no violation of neutrality because of Article 103 of the UN Charter, the Supremacy Clause, that Council obligations under the Charter, and that includes binding Security Council decisions, trumps, that word is problematic these days if one uses Trump as a verb, but it is stronger. It has precedence over other obligations under international law. So the obligations under neutrality have to yield to a charter decision. So that's so far so good. Then there's a very interesting debate at the moment going on specifically in relation to the Ukraine. But if there's an act of aggression, then neutrality doesn't apply at all. Then there's Austria and Switzerland and Ireland and Malta can also actually support the Ukraine without being involved, without violating neutrality. Now, traditionally, this argument is problematic. Of course, if the Security Council has identified the aggressor or the one responsible for a violation of the use of force, Iraq War 1990, that's different. Then we're back in the policing paradigm. But the problem, as you know, with self-defense and it's the constant abuse. People, it's most of the time, states have to decide for themselves. This is a unilateral measure, and they're always accusing one another of you shot first, or you attacked first, you attacked first. So it becomes a very difficult and arbitrary exercise, and it's very difficult to find the evidence and so on. Now, it's true that in the case of the Ukraine, that is different, because we have the United Nations General Assembly resolution that clearly, with a very large majority, determined that there is an act of aggression in the Ukraine and that Russia is the aggressor. So the legal uncertainty that you usually have, or very, very often have in the self-defense context, is in that way much less in the Ukraine sense. And while the GA doesn't have binding powers, it does have a lot of political weight. So we can say safely, we could identify the aggressor, the typical uncertainty that you have in so many other cases where self-defense is invoked by states, always accusing the other one. You have it in Nagorno-Karabakh as well at the moment, Azerbaijan and Armenia. It's not clear who actually started the fighting first since 2 or 3 years ago. That's very typical in this context, but okay, with Ukraine, that is different. However, there are still two things that you have to keep in mind. That the whole philosophy behind neutrality has to do with containing the conflict, trying to prevent the conflict from spreading. So this argument that in the case of aggression, that philosophy contradicts the argument that in the case of aggression, neutrality isn't relevant. And the other, to me, just very relevant fact is that the state practice, the two main protagonists, Austria and Switzerland, have not made this argument. To the contrary, you may disagree whether they're actually acting neutral in all sorts of ways, but they are not following this line of reasoning. They're not saying that in the case of aggression, there is no neutrality. So this is a big debate that is going on, and I don't know where it will end, but for the moment, states like Austria and Switzerland do not seem to embrace the more progressive view, namely that neutrality doesn't apply in this context. Okay. Now, this, okay, so we are not, just to conclude and to open up the discussion, we can delve into some of these issues in more depth during the discussion. There's an increasing uncertainty regarding the utility, the relevance of the law of neutrality in modern international law. Many would argue that it is overhauled, that it doesn't fit. The United Nations Charter did not actually abolish the adoption of the Charter and so on, didn't abolish neutrality. Like it's still, you can still facilitate neutrality within the Charter. Interesting also for EU members like Austria and Ireland, the EU law is also drafted in such a way, and we can talk also a little bit about that if you wish, but the defense component under EU law facilitates, allows Austria and, for example, also Ireland to maintain its neutrality. The doctrine of constructive abstention, for example. And we also have in the EU the Bündnisklausel, the loyalty, the assistance clause, determining, I think it's Article 42(7), that countries will assist one another, EU countries in the case of an armed attack. But also that clause, read together with the Irish clauses with the additional protocols to the treaty, makes clear that it's up to each country, EU member, to decide how it will assist a member being attacked. So formally speaking, if you're a neutral state, you can, maneuver yourself around this, but politically it's becoming increasingly difficult because it is being perceived as cherry picking. Because a country like Ireland or Austria, if they would be attacked, they have the support of other EU countries, and they have the benefit of calling on their EU partners to assist them. But on the other hand, when somebody else in the EU were to be attacked or in trouble, they can keep out of it and have much more leeway than the other states might have. So this is observed, if you speak, by many in the EU as no longer really working or politically feasible, especially now in the current political climate, also that there needs to be a recalibration of how all of this is managed. But it is also internally an issue that needs discussion, and it has become an important part of the identity of many people living in Austria. They have, since 1955, it's been a neutral state. This is politically, for many in the society, important. So this is an issue that you need to discuss. And my sense is that this is also being rediscussed in Switzerland because there is a changed reality. But this is not an issue. You cannot just ignore the domestic political context. You need to convince the political domestic constituency that this is in their own interest. And I think this discussion is taking place, but it may still take a while for people to really understand and accept that change may be needed. And another area, and we can perhaps talk about that in the discussion, where the economic sanctions are becoming rather tricky, and that shows you also how the world has changed since 1907. As you know, many of the economic sanctions, the financial sanctions, also include the freezing of the assets of the Central Bank of Russia. Now, there's on the one hand an immunity issue, which I will not get into today. That's a different debate. But do you violate the law of immunity, and what are the consequences of that? And I think that's a very serious discussion that also needs to be had. But, is now in the strict sense, of course, financial, the assets, the money in the central bank, it's not military equipment, but it's also extremely vital to the sustaining of the whole military campaign. And that also illustrates how difficult it is to distinguish between non-military goods and military goods, because without millions of dollars in the bank, you cannot finance your military campaign. But once again, there's very little state practice, so it's a very gray area. Nobody thought in 1907 that we will EFT transfers, and this freezing of assets and these kind of things, and the way the world works today in cyberspace and cyber warfare, all of these things, none of that was relevant in 1907. So we have to apply very old rules in a very, very different context. And the countries that are really affected by that are struggling to find their way in this changed legal and political environment. And I think I will stop with that. Thank you very much.
Thank you very much for this lecture, which not only got us back to the fundamentals of the question of neutrality, which is indeed a very good topic for discussion, because it's considered to be under international law by many as something which is quite outdated, something old-fashioned. Finally, we are talking here about something which comes from the late 19th century, something which came into existence in the time when we certainly could not talk about the prohibition of the use of force, where and the rules of IHL were only to to become existent. So the question is how much this developed and what are the problems arising in the current context. And I'm really happy that you pinpointed basically the different aspects and also those issues which are currently the matter of discussion and which are widespread not only in the media but also in academic discussions, just like you mentioned the question whether the delivery of airplanes, how to deal with this. And I think the slippery slope is a very nice term to describe actually the problem which we have here, to distinguish between actually what is still to be considered as a part of neutrality, whether we talk about it as a legal status or as a course of foreign policy, because neutrality is both. And so that describes, and you pinpointed very nicely and understandably the problems which arise in the current conflict, in the context of the current conflict in Ukraine. So thank you for that. Well, I would of course like to give the floor to the colleagues sitting here, and maybe I will be able, if there are any questions also from colleagues who are watching, to collect some questions also from the chat from YouTube. But
can I just make one? You raised the very
Of course.
important issue of foreign policy. I think just from a legal perspective, what is different in Austria and also in Switzerland from Finland and Sweden, where that while they were neutral, that was a political decision. It was a foreign policy decision. And these are deeply democratic states. So that is what the society wanted. But then when the society now in recent times decided, no, this is not working anymore, they had to vote in parliament and there was a debate, but they didn't have to go through a changing of the constitution and things like that. That is what you would need. In Austria, you would need to change the constitution. Whereas in Finland and in Sweden, it was a policy decision, it was political. They were not legally neutral in the sense that Austria is it.
Thank you. So I'll just open the floor for questions you might have in this context.
I think that this is also security decision. Austria or Switzerland were in the same geographical position like Finland and Sweden. They would probably also became maybe a member of NATO. That it's.
Yes, I think that those countries have very, very different histories. I think if you have, Finland has a very difficult and complex history, and it was attacked in the previous century several times by Russia, whereas I think Austria's history with Central and Eastern Europe and Russia is also a different history. So I think these things.
It's combination.
It's very complex, and it's relationships that go back many hundreds of years and so on. And these things, and the economic ties are different. I think that's also a different issue.
Questions from the audience.
So thank you very much for your interesting lecture. I think we need more and more lectures on those topics, especially these days. And I have two questions. One is more of a general nature, and the second is more maybe specific one. The first one is, do you agree that the European Union, by imposing sanctions, mainly financial sanctions, but not only, there are also some sanctions imposed on Russian figures, they cannot move to the Western Europe and so on. Can we compare, or would you compare, or do you agree that we can compare these sanctions to the sanctions which can be imposed by the Security Council under Chapter 7 of the Charter, non-military sanctions, like in general, like what's your opinion on that? And the second question is, because you said that there can be a violation of neutrality, impartiality of a state, who decides about that? Who decides whether there has been a violation of a state's neutrality, impartiality by these states made?
Okay, so thank you very much. I'll start with the second question. Well, in international law, because it's decentralized, third states, but obviously the ones with the biggest interest. And this is what makes this so risky. Of course, Austria's European neighbors and its EU neighbors have over the years observed that Austria has made the best of its neutrality in the sense it interpreted its obligations very, very narrowly. Okay, what they have to do, there's even a debate now as to provision of weapons. Is it only lethal weapons as to non-lethal? Okay, so it's like shrinking your own obligation while benefiting from all the other benefits that you have within the EU. Now, obviously, the EU partners were happy with that. That suited their interest, but they are not the only ones who decide whether there's been a violation of neutrality. Obviously, in this case, the Russian Federation has something to say about this. And from the very beginning, since 1955, Russia was the state with the biggest interest in Austrian neutrality. It insisted on that neutrality being embraced and anchored, respected in the first place. So that is an issue that you cannot entirely forget, and that makes all of this so risky. And if I can just take this broader, I'm not only talking about neutrality, and this is where my African kind of reflex comes in. We often find in Western Europe and in the EU and in the WEOC countries that we tend to be very exceptionalist. We can bend the rules and we can do things differently because we are the better guys. We are the ones who are on the moral high ground. If we bend the rules, yes, of course we do it because we want to export democracy or something like that, and therefore it's okay. That is a very, very problematic position to take, because the law is not only made by the EU and its allies, even of course we do influence the law and it's 27 states and so on, but other states also have a say in this. And if we start bending the rules, we shouldn't be surprised that others do the same or abuse the arguments in a very cynical way, which we use to justify this bending of the rules, to do that. And especially with China on the rise and becoming extremely strong and observing our tactics, just copycat, waiting for the right minute to copycat them. So that's why I'm thinking whenever we bend a rule or cherry pick, whether it's neutrality or whatever, just remember other states can do this and they will. They may not be strong enough now. Russia wasn't strong enough 20 years ago. China neither. But the geopolitical situation is changing. So that's more a political answer that is relevant for the neutrality answer, which in this case means yes, also the Russians have a say in this, but or they have their own interpretation, and of all of this. But it also affects other areas of international law, and I sometimes think that we in the West we forget that it's not only the United States and its allies or the EU and its allies that decide how international law is made. Okay, to get back to your second question, are you asking about the legality of third-party sanctions? I would say that general. I think it's a collective measure. It's a collective reaction against one of the worst violations of international law. And it's, of course, in the context, we won't get a Security Council resolution. But there's also, in this case, there are legal bases. For example, there's inter alia the EU-Russia Partnership Agreement dating from either 1991 or 1994, which it's about investment and economic trade and so on, but there are exceptions. And one is, I think, from the top of my head, Article 99(1)(d), that explicitly provides for restrictive economic measures, all sorts of measures in the case of war, threat to international regional peace and security. And then the question that arose, the Rosneft case before the Court of Justice, the question was, but this conflict is not on EU territory. It's in the broader European sphere, but not in the EU. So can you trigger this exception clause in this context? And the court said yes. And I think if you read that clause, it's about also international security. It almost reads like Article 39 of the UN Charter. So there is a treaty that, at least for some of the sanctions, that can be based on that. And there's even an argument that you can make. It's a very interesting one, and it's being made by Russell Buchan, who will be visiting Olomouc, I think, in September, in a recent article in the ICLQ, International Comparative Law Quarterly, that even the right to self-defense allow you to impose sanctions a maiore ad minimus. I think, if you can even impose military, you can also do less, which is more proportionate, the proportionality necessity argument. The interesting thing is, it doesn't seem that states actually use that option, because remember, if you invoke Article 51, you have to inform the Security Council. And in the Falklands War, in 1982, it seemed that the UK actually, and then it wasn't the EU, it was the EEC. 10 EEC members actually sanctioned Argentina in response to the aggression in the Falklands. And they informed the Security Council. And from that, you can argue that seemed like an implicit invocation of Article 51, because of why otherwise would you inform the Security Council, if you impose a sanction? But in the current conflict, it doesn't seem that states actually use that avenue. There's also the WTO clause, Article 21 of the WTO. So there are all sorts of collective treaties which you can, can go through. And which I think you have to use at the moment. And there's also an argument that customary international law simply doesn't prohibit these kind of sanctions. So instead of doing them one by one, the EU is doing it collectively. Does that answer your question?
Yeah, thank you very much.
Okay.
And I think we will stick to maybe to the question of self-defense, because we have a question also via YouTube from our colleague Agata Klečkovská from the Polish Academy of Sciences. And Agata asks whether states providing assistance to Ukraine claim that grounds is the right to collective self-defense. How the participation in collective self-defense influences the status of a neutral state?
Okay, so I definitely think it would be a violation of neutrality. And then once again, the type of measure that it would not necessarily terminate. Because
Agata posed apparently a good question.
It's a very good question. It would definitely be a violation of neutrality, but the question then becomes, does it also make you a co-belligerent? And there I would say no, because none of the, it would depend on the type of measure, okay? What we've discussed. If you allow your state to be used as a launch pad, or obviously if you join the war, like the United States did after Pearl Harbor, only at that, they gave massive amounts of weapons to the United Kingdom during the Second World War. Okay, but that's before the Charter, but they only became party to the conflict after Pearl Harbor. Once again, I don't think that military assistance, any form of military assistance, whether it's on the basis of Article 51 or whether it's on the basis of just a trade agreement, remember, you can, from government to government, you can in any case trade in arms. There's nothing in principle in international law that prevents the recognized government of Austria or the Czech Republic to provide weapons to the Ukraine. There would be a problem with providing weapons to the aggressor, because then you become complicit in an act of aggression. But okay, in this case, we know that Ukraine is the victim. Okay, but if you're a neutral state and you provide any form of military assistance, you violate neutrality. if you invoke Article 51, self-defense, okay, but I think what she's getting at is if that actually terminates the neutrality. I would say it would be a grave violation of the law of neutrality. It may even terminate the law of neutrality, but not to the point where you become a co-belligerent, because to me, that is another level. And I'm very concerned about the whole issue of how you can get the fighter planes into the territory. And I suspect the military people are not allowed to discuss that in public, because there must be ways. And I understand that we perhaps cannot discuss that, but that to me is and I think that's obvious. If you want to move something that big, you know, into a war zone, you have to think of ways to do that. I hope I answered the question. Yes, it's a violation. It may even terminate. Neutrality, but not yet to the point of being a co-belligerent, unless there's this very, very close causal link between a particularly military action by the Ukraine and the type of aid that the neutral state gives to it. Very good question. I told you, always the Polish colleagues in these kind of ask the toughest questions.
Thank you. Are there any questions on the If I make my questions will be easy, definitely. Thank you very much, Professor, for your splendid presentation. I've got a lot of notes here. Probably we don't have time to reply to all questions, so I will give you two questions if it's possible. The first one concerns the aspect of your presentation when you asked when the law of neutrality is not applicable. So you refer to Chapter 7. And then you raise possible questions, which is very controversial, obviously, that law of neutrality is not applicable in situation when there is an act of aggression. So if you please comment on that in further details, because from my perspective, it seems to me that it mixes up two branches of public international law, use a bellum and using bello, and the question is whether whether it is acceptable. And secondly, with your permission, we've got a really huge discussion here in the Czech Republic concerning the possible participation of persons of Czech nationals in the conflict in Ukraine. And here the question is, it's quite tricky, because if these people decide to participate actively in the conflict, even if they are incorporated in the armed forces of Ukraine, from the perspective of Czech legal order, they are committing an offense, criminal offense. And under principle,
so mercenaries then, or
not mercenaries.
But you may not fight for a foreign force.
Czech criminal code.
You cannot fight for another.
Exactly.
Many countries have that.
Exactly. Yeah. So the question is whether it is more or less similar in Austria, because we've got a really huge discussion, and according to the principle of legality, it would be up to public authorities to prosecute, and they would be even obliged to prosecute them. So the situation was solved by the public pronouncement of a former president. It was really for a good point, that he promised that he will grant and he will enjoy and employ the constitutional prerogative. So he will grant
amnesty.
So it was solved. And here the question was whether it is somehow compatible with the law of neutrality. So I would be curious whether there was some similar discussion in Austria.
Very good, very good point. Not easy questions at all. The first one I can answer. I think I entirely agree with you. I have great difficulty with just this whole argument that it doesn't apply in the case of aggression. I mean, that's just but it is being. It's actually in German literature. It's there's a whole. It's very strongly kind of supported by many colleagues. But my concern is also the arbitrariness, because who decides? Now, but they have a strong counter argument in the Ukraine situation, the Ukraine context, because we have the UNGA resolution. Okay, so there, I think you can make that argument. That I have to concede that's a relatively strong argument, but I fully agree that once the Security Council actually indicates the aggressor, or in the case of the Iraq War 1990, it didn't call Iraq the aggressor, but it was clear that Iraq had to get out of Kuwait, and they were force was authorized. Then you're in a different paradigm. in general, when aggression is at stake, I think it's very risky to make this argument that now neutrality is not relevant. You might argue in the Ukraine case that because of the GA resolution, the legal uncertainty isn't there. But once again, the practice of the most affected states, Austria and Switzerland, actually more goes into your direction. They're very reluctant to embrace this. Okay, so that was the easy question. Just the second one again, that was the
participation of nationals.
From my understanding is that Austria had a similar law. I think most European states will probably have something like that. You're not allowed to fight for under the flag of a nationality. Somebody mentioned that to me about a year ago. And I honestly, whether that has changed and the extent to which that's being debated, but I cannot imagine that is being encouraged in Austria, because it can even be perceived politically. Look, if you do this on your own, then you, I actually have to check whether that's a violation of the law of neutrality. I don't know whether somebody knows that from the top of their head. I think not. But politically, it may still be perceived like that, because there's a legal dimension and there's the perception. Yeah.
Thank you very much.
Because it's not authorized by the state. I mean, you're doing this from your own initiative. You're going there as a private citizen. So my sense would be that it's not legally prevented by neutrality, but politically you are observed as, you know. So.
I think that if I may join the discussion, because there was this kind of discussion also in the Senate of the Czech Republic on this, and it's really a tough question, because it's not only whether the state is active in terms of
but preventing,
but also whether it's not preventing, or for example just adopting the laws which would enable
duty of care, the Sorgfaltspflicht in German.
Exactly. So just to enable the people to go there and to fight there. So in other words, the state is not at all saying, yes, we support you, or go there, or do whatever. It's just saying, okay, we will not punish you if you go there.
But that's an interlace, you know, that's also,
exactly.
Yeah. So I don't think this is that's one way of getting drawn into a conflict sooner rather than later.
Yeah. Exactly. Okay.
If your aim is to stay out of the conflict, yeah.
So the states are apparently discussing this because they are fearing, actually, the Czech Republic is not a neutral state, but still the state is apparently fearing not to cross the line. And that is one of the discussions. Any other questions?
Yeah, I have one question, because the topic of the sanctions and actually the breach of the neutrality is quite an interesting one. And I was wondering, by joining the organization which compels you to abide by decisions in terms of foreign security policy, including arms embargoes, etc., but it is not already a waiver in some term, in some extent, neutrality, because you are simply obliged by the treaty to comply with these sanctions. So already by being a member of that organization, you might waive part of neutrality.
Well, yes, but you know, that's Pacta Tertiis. I mean, you still remain under public international, also responsible for your treaty obligations. Austria is a part to the two Hague Conventions of 1907. And by joining the EU, it doesn't relieve itself from its obligations under the Hague Convention, but the discussion we had earlier today, so then you have to try a harmonious interpretation. And there you have, to some extent, the change of time on your side, because you can say, well, the law is evolving and there's just no state practice about the freezing of assets in 1907. Yes, but that wasn't done back then. So you can argue either way. You can say, this doesn't somehow seem to be very neutral. The principle of neutrality and keeping out of everything doesn't seem to be respected. But I think a part of your question is a political question, that there's this, if you join an organization, it has consequences on your, well, on your sovereignty as well, and your freedom to take these decisions. And the Austrians and the Irish did very well politically for themselves, and the Malta and a few other, in negotiating the so-called Irish protocols. It was the Irish actually that insisted on those protocols about allowing them to allow certain decisions to go forward, but without being obliged to do that legally. But politically, this becomes unsustainable, and you need to have solidarity with the rest of the EU. And that is where Austria is also now. And I think they understand that. I don't know what the debate is like in Ireland. I think also geographically, they are a bit more isolated in this current context. Because effectively, yes, the reason why Austria is interpreting its obligations increasingly narrowly is exactly because they've joined the EU. Switzerland has more leeway in that, but I've been told by colleagues in the foreign ministry that the political pressure on the Swiss from very powerful states, which I will not mention, were such that they just followed all the sanctions that we're all doing. They've also freezing, all sorts of things are being frozen in Switzerland, which 2 years ago would have been unimaginable. And it's also not going with, you know, it's also, and I really respect that. I lived in Switzerland for 5 years, and they have a very deep democratic tradition. And this is something, even if you don't agree with their position, you have to respect their traditions and their way of taking a decision and so on. But apparently there is a huge discussion also now about whether they have to adjust some of their policies. There was something else about your comment. You see, Austria adjusted its constitution, because you have neutrality in the Austrian constitution, and which is always a nice exam question, because it's a wonderful example of a unilateral act in public international law that is binding on the international plane, because, you know, the expectation, the good faith, and so on. And interestingly, that they at the time, all the states, the Austrian states with which Austria had been engaged in, they were notified about Austria's neutrality. It was accepted. When Austria also joined the United Nations very early on, whereas the Swiss only joined in 2002, there was no objection against Austrian neutrality and so on. And then when Austria joined the EU, it adjusted the constitution again. I think it's Article 23J, in which it also made clear that it is committed to fulfilling all its obligations to the EU and the whole solidarity obligation. So on the so from a constitutional perspective, the neutrality is waived. That's though you use the term waive. From the constitutional perspective, they can justify the waiving of neutrality in the interest of EU policy. But that's not the end of the story. You have the international level, and that's where your question comes in, who decides? Other states as well. It's not only the EU states. So that's where the tension comes in. They resolved it on the constitutional level quite okay, and to accommodate the EU obligations, and effectively waive neutrality in the interest of EU obligations. But you cannot do that vis-a-vis third state, pacta tertis. So that's where the tricky thing comes in.
Thank you. Any other questions before we conclude? If not, and I also don't see any other questions coming up in YouTube, so I would like to take the opportunity to thank Professor de Wet once again
Thank you
for the great lecture and also for coming to Olomouc. We're looking forward that there will be more collaboration, more guests from Graz.
Thanks.
So we're looking forward to enhancing the collaboration. Thank you also to all of you who came today here to the Faculty of Law, and also to those of you who watched this lecture online. And wish you a nice and pleasant evening. Thank you.
Okay, all the time. Okay, rather 10 all the time, then 100 in the beginning, and then 99 drop off. So did you know any of the online people? Oh, it's a YouTube, it's a training, then you can. Oh, okay.
Thank you.
I hope this was okay for the military leaders perhaps, they're more interested in the IHL part than, but that's not my big strength. How did you transport airplanes?